So in the proposed ordinance, attached to it is the framework of the tentative agreement that the city and the PPA have agreed to regarding clarification of policies in the collective bargaining agreement. And in that provision, it states that for investigations other than those involving use of deadly force and incidents of in-custody death, prior to the internal affairs, IPR, or EEO interview, the officer will be afforded a reasonable opportunity to review the officer's police reports and body camera, audio, video, and other audio video that the officer reviewed at the time they wrote their report. And there's a note that deadly force incidents and in-custody death and audio video review is to be set forth in Directive 10-10-10, which is investigations into deadly force incidents and in-custody deaths. There is a provision also that notes that this Directive 10-10-10 that governs deadly force and in-custody death, audio video review, and the proposed body-worn camera policy is subject to mandatory bargaining. And under state law, and the caveat being I'm not a labor lawyer, but under state law, we've done some research, and the NLG has provided that legal research to the city. One of my colleagues, Kristen Chambers, brilliant attorney, wrote an excellent law review article back in 2013 when this was an issue, looking at the issues of permissive versus mandatory bargaining in the context of IPR, right. Compelling testimony, that issue. And the conclusion that we reached in looking at the current state of the law is that when the officers get to review body camera footage of an incident, whether in custody death, deadly force, or not, use of a taser, the city's position right now is that when the officers get to review that, whether it's before their interview or after their interview, that is subject to mandatory bargaining agreement. Based on the NLG's review of the state labor law, and where the Employment Relations Board has issued rulings on issues related to investigations of employee misconduct, potential employee misconduct, when those officers get to review that footage, should not be subject to mandatory bargaining. That is, our position is the city can say, police officers, you don't get to review video of an incident before you get interviewed. The purpose of these interviews is to get the employee's recollection, the employee's statement on what happened, their best recollection, because that's an investigation.
That's right.
If most employees, almost all employees, except for in this situation with Portland police officers, do not get to review footage of an incident before they are subjected to an interview. They get to have a union member present, they get their attorney present in some cases, and we have no objection to that as being subject to mandatory bargaining. But the issue is that the city should be able to say, without mandatory bargaining, without having to get the PPA's approval, because if I'm the PPA, I'm not going to approve and agree to not allow the officers to review that footage either.
Right.
But the city has the obligation, I think, to the community here who's pushing for effective oversight to say you don't get to review footage before reviewing those, being subjected to an investigation and giving a statement about a particularly high-level incident.
So what I'm most troubled by is that even though the body cam ordinance has been taken away, if this contract is approved, this becomes the standard under which any policy will be developed. So when I kept asking the city council, why would you delegate the responsibility for developing a public policy to the police bureau? That's the answer, because you've already bargained away the public's right to actually hold police accountable. And so that's why the mayor is delegating it to the police bureau.